to implement Global Magnitsky, GLOMAG. There is an irony here because the Obama administration had resisted the legislation. It didn't like GLOMAG legislation. I sat in on endless meetings where arguments against it were heard. The legislation passed anyway, and it fell to the Trump administration, which has an interesting relationship with human rights as a guiding principle in international relations, to implement. And it is a pleasure for me, if I may say so, to note that the Trump administration has implemented GLOMAG in a capable, credible way, thanks in no small part to Andrea, the work of Andrea and her people. So we're going to start out with remarks by Andrea, and then she'll be joined by our panel, led by Samantha Sultoon. Samantha, as I said, was an OFAC. Well, I knew her when she was in OFAC, working a little bit on Russia, but mostly on Burma and other Asia sanctions. Now she's joined the Atlantic Council, where she is one of the pillars of our sanctions program. And we cover a lot. She has written a paper on GLOMAG, arguing that it sets out new standards that businesses should pay attention to. She's also co-written with Brian O'Toole a piece outlining the latest piece of Russia sanctions legislation that's been introduced in the Senate, doing a quick and accurate analysis of it. So plenty of work is being done here on sanctions. And now, Andrea, I think it is your turn to speak, and thank you very much for coming to this.
I may have messed up my mic. Just a second. I'm sure it's fine. I just want to say to you what a pleasure it is to be here today and to be back here at the Atlantic Council. And I'm grateful to everyone for being here for this important event. And I'd like to thank my friend Dan Fried for his kind words and his introduction, and for his indispensable contributions to national security during his long tenure in public service and now in the think tank world. And I'd also like to thank the rest of Ambassador Fried's team here at the Atlantic Council for organizing this event and for dedicating staff, resources, and expertise to the study and research of financial sanctions. As Ambassador Fried mentioned, I am the director of the Department of the Treasury's Office of Foreign Assets Control. OFAC and the Treasury Department more broadly has a range of tools at its disposal to advance U.S. national security and foreign policy goals and combat rogue nations, terrorist facilitators, and other threats to U.S. national security and foreign policy, including major human rights abusers and corrupt actors. In countries around the world, innocent people continue to live under fear of starvation, forced labor, arbitrary detention, torture, rape, and even execution. All the while, corrupt political leaders and their families embezzle their country's wealth, lining their own pockets at the expense of their citizens. Sometimes human rights abuse and corruption go hand in hand. For example, human traffickers motivated by greed are killing, impoverishing, and terrorizing innocent civilians around the globe. Traffickers prey upon innocent people, selling them into slavery and into the sex trade for profit. The president has determined that the prevalence and severity of human rights abuse and corruption around the world have reached such scope and gravity that they threaten the stability of international political and economic systems. And in December 2017, he declared a national emergency to deal with that threat. While OFAC has long used its powerful authorities to isolate and deprive such actors of the resources necessary to perpetrate their crimes, the sanctions authorities under the Global Magnitsky program have given us even more flexibility and latitude to do so. And I'd like to briefly describe OFAC's role in targeting corruption and human rights abuses and violations, then outline OFAC's current activities and strategy to maximize the impact of U.S. government sanctions with a particular focus on the Global Magnitsky Sanctions Program. As I mentioned, targeting serious human rights abusers and corrupt actors has long been a long-standing element of Treasury's sanctions programs. During World War II, a group of very smart professionals at the Treasury Department realized they could use financial tools to counter the Nazi menace and help its victims. They seized U.S.-held assets of countries that the Nazis invaded, and later during the war, they facilitated sending those funds to Europe to help Jewish children escape from Nazi-occupied areas. Since then, Treasury has continued to sharpen and to wield its financial tools to impose serious consequences on those responsible for human rights abuse and corruption, while protecting victims and supporting those who stand for accountability, for transparency, and for the rule of law within their governments. Approximately half of OFAC's sanctions programs have human rights or corruption-related designation criteria, which we've used consistently to sanction persons engaged in those crimes. These sanctions programs, many of which go back years, include Belarus, Burundi, Central African Republic, Democratic Republic of the Congo, Iran, Libya, Nicaragua, North Korea, the 2012 Magnitsky Act, Somalia, South Sudan, Syria, Ukraine, Russia, Venezuela, and Zimbabwe. In this administration alone, we have sanctioned over 500 individuals and entities with a human rights abuse or corruption-related nexus. Since April 2017, we have issued a tranche of designations every single month against individuals who had a human rights abuse or corruption-related nexus. For example, on January 8, 2019, OFAC designated 7 individuals and 23 entities who were involved in a significant corruption scheme designed to take advantage of the government of Venezuela's currency exchange practices, generating more than $2.4 billion in corrupt proceeds. This designation targeted former Venezuelan National Treasurer Claudia Patricia Diaz-Guillen and Raul Antonio Guerin Belisario, who bribed the Venezuela Office of the National Treasury in order to conduct illicit foreign exchange operations in Venezuela, among others who played a role in the bribery scheme. Additionally, we took action in December 2018 against 3 individuals for their role in expanding or extending the conflict in South Sudan, or in undermining the peace, stability, and security of that country. By imposing financial sanctions on these individuals, we can ensure they pay a cost for perpetrating violence and that they do not profit from such abuse. And these statistics demonstrate how seriously the U.S. government as a whole, and OFAC in particular, is taking this issue. But one of the most significant additions to our sanctions regimes, to our toolkit, and the reason we're here today, has been the Global Magnitsky Sanctions Program. In December 2016, the president signed into law the Global Magnitsky Human Rights Accountability Act, or GLOMAG Act, as we call it. The GLOMAG Act is a separate legal authority from the Magnitsky Act, which I know folks here was designed to primarily target persons for certain actions related to the case of the Russian lawyer Sergei Magnitsky, who in 2009, after being arrested and tortured in custody of the offices of the Ministry in the Interior of the Russian Federation, enabled sanctions to be imposed on those related to that act, and then human rights abuse and corruption in general. Building on the GLOMAG Act, however, in December 2017, the president signed Executive Order 13818, which implemented the provisions of the statute to target human rights abusers and corrupt actors abroad, as well as their abettors, including those not covered by another sanctions program. Under GLOMAG authorities, we have designated a slew of corrupt actors and human rights abusers, including current and former government officials and their networks around the world. Treasury's financial tools, including our GLOMAG sanctions programs, make it difficult for designated persons to conduct business abroad, as many financial institutions throughout the world implement and screen against our sanctions list. We've been pleased to see a number of public reports on the impact of our actions. Some of the designated individuals are now seeing themselves cut off from lucrative business arrangements, and others are being investigated by their home governments. Treasury's actions under these authorities send a message to those responsible for the suffering of others and profiting from corruption that there is a steep price to pay for such actions. We've implemented our GloMag sanctions in order to have the utmost impact. For example, on major corrupt actors like international businessman and billionaire Dan Gertler, who was listed in the Annex to Executive Order 13818 in December 2017. Gertler amassed hundreds of millions of dollars through opaque and corrupt shell company facilitated mining and oil deals in the DRC, in part by leveraging his close friendship with DRC President Joseph Kabila. We've been particularly focused on using our GloMag authority to identify and target not only individuals but also their networks in order to disrupt their support system of enablers, associates, businesses, and business interests. For example, when we imposed sanctions on Gertler, OFAC simultaneously designated 19 affiliated companies and one additional individual in his support network. And then we went further. In June 2018, we followed up with designations going after more of the Gertler network and targeting 14 companies who continued to enable his access to the international financial system and profit from corruption and misconduct. And there's no question that Gertler is feeling the consequences of our action. In June 2018, for example, we also took action against the Dominican Republic senator, along with 5 of his companies, for corrupt acts in his home country and its neighbor, Haiti, as he had attempted to illicitly profit off the humanitarian aid that went to Haiti. One of his companies was paid over $10 million for post-disaster rebuilding work it had not completed. This is another example of the importance of designating not just an individual, but also entities they own or control to ensure maximum financial impact. But we've got to be mindful that financial sanctions are just one tool in a whole of government effort to disrupt and deter serious human rights abuse and corruption. Often our sanctions complement other actions by the U.S. government, including visa denials, capacity building programs, or diplomatic efforts. By working in lockstep with our partners in the interagency, we can maximize our efforts and sequence the use of our authorities in a smart way. But in some cases, financial sanctions simply aren't the best or the most effective tool. We constantly look for ways to apply our measures where they can effectuate a behavioral change and have a real impact, but we know they aren't a one-size-fits-all approach for every foreign policy issue. Our efforts to target human rights abusers and corrupt actors have been greatly aided by our partners in Congress and the interagency, but also by civil society groups, human rights activists, and think tanks like the Atlantic Council. If we are going to deploy these tools to maximum effect, we have to be informed by a diverse group of experts, both inside and outside the government. We need open lines of communication between the private sector to ensure it understands the risks of dealing with human rights abusers and corrupt actors, but also to remind them of their due diligence obligations. And finally, we need to work with the international community. The United States has historically protected, promoted, and enforced long-standing international norms alongside our partners and allies. Multilateral sanctions are always stronger than unilateral ones. So finally, I just want to conclude and get to our discussion. But as you've seen over the last 2 years, we at OFAC have imposed tough sanctions. Treasury has issued financial advisories, and the interagency group as a whole has undertaken diplomatic engagements to counter human rights abuse and corrupt actors across the globe. We are leveraging our authorities, including GloMag, but all other ones as well, to change the calculus of malign actors. We're sending strong, powerful, and impactful messages that there are dire financial consequences to their actions, and that their access to the U.S. financial system will be cut off, and their assets will be frozen if they don't change their ways. And we're pressing other governments to do the same. Thank you.
If I could invite all of our panelists up on the podium, please. First, I'd like to start by thanking you, Andrea, for your very insightful remarks. I really appreciate them, and it's also a privilege as a former OFACer to be sitting next to you and facilitating this discussion, so thank you for being here. I don't think at this point you need any further introduction, but I would like to take this opportunity to introduce the rest of our panel. So next to Andrea, we have Clay Porter, the head of investigations and a managing director in the Global Investigations and Compliance practice at Navigant. Clay previously held a number of roles at the Department of Justice, among them a trial attorney and acting principal deputy chief of MLARS, the Department of Justice's Money Laundering and Asset Recovery section, among a number of other roles. Next to Clay, we have Steve, who I had the pleasure of working with under the previous administration. Steve has a wide range of experience in the human rights field. Currently is serving as the director of the International Crisis Group's U.S. program, and previously was special assistant to President Obama and senior director for multilateral affairs and human rights at the National Security Council, among a number of other notable roles. And next to Steve, we have Jerry. I'm personally very excited to see Jerry in DC after his 5 years in Brussels at the European External Action Service, where he was the deputy head of EU sanctions. He's now the first secretary for sanctions at the British Embassy, in a new position that's just been created to coordinate UK sanctions after Brexit. So Andrea's remarks gave us a lot of points to think about and discuss, and I will try to refrain from taking too much of the moderator's prerogative, but wanted to start with a couple points, the first of which Ambassador Freed alluded to at the outset. So by taking us back a few years, under the previous administration, the Human Rights Sanctions Authority was discussed but not pursued. And we had the opportunity to raise this last week with former Treasury Secretary Jack Lew when he spoke here at the Atlantic Council. Some of you may have been in the room. When we asked him why he didn't think it was worth pursuing, or what his take was on that issue. And he explained that he had generally cautioned against using the sanctions tool for messaging purposes because he thought it would dilute the tool more broadly. So I'd like to just unpack that issue with the panel, both in terms of the policy side, the NGO side, and also from the operational side, from the business side. Where do you take that perspective of saying, well, does this actually dilute the tool, to all of the very notable examples that Andrea gave, where I think there's an argument on the other side too, and how do we see the tool going forward?
I'll start very quickly. I think that, as Secretary Lew noted, sanctions, and it's an analog that sanctions are intended to change behavior, and to do so, they've got to have at least some pinch, if not some real effect on the people who are the targets of those sanctions, meaning access to the U.S. financial system, by one example, access to U.S. actors, there has to be some leverage the U.S. Government or the U.S. Financial system has in order to make those sanctions really work. Whatever the reservations Treasury expressed about the Global Mag Authority in the past have almost been removed through the interagency application of those sanctions. Some of the sanctions I noted, including, for example, the Dan Gertler corruption-related sanctions and network, have shown that these sanctions can have real impact.
Steve, I don't know if you want to jump in based on your previous experience.
So that was not obviously a uniformly held view within the Obama administration. I know that it was one that Treasury held very strongly. I disagreed with it then. I disagree with it now. We invited a number of experts in to talk about that concern at the time. We brought in Nobel Prize-winning economists and former national security chiefs and asked them the question, is this going to dilute the sanctions tool? And I think the almost uniform feeling was no, it wouldn't. That it might if you looked like you were using sanctions arbitrarily, but if you were using them to advance a globally, universally recognized norm in support of human rights, that was actually sort of a safe harbor, and it was the right kind of use of sanctions. So, we thought this was a perfectly legitimate, we in the sort of human rights community inside the government thought this was a legitimate and useful channel for economic statecraft. I think, to echo the point that Andrea just made, and made in her remarks, nobody thought that sanctions was itself a surrogate for policy. Sanctions were a tool in the service of a policy on atrocity prevention that the president had already announced. They were a way of creating leverage. They were a way of creating costs for perpetrators. They needed to be linked to a diplomatic strategy and clear demands. They would be more effective if they were imposed multilaterally than unilaterally. But they were a tool that we wanted to use, and the creation of a global instrument like Global Magnitsky or the atrocities executive order that we talked about in the Obama administration was intended to lower some of the internal transactions costs around imposing sanctions, so you didn't need to go through the exercise of creating a country-specific order at the time. And also to avoid some of the unnecessary friction that came with having to declare a national emergency with respect to a particular country. So you had this standing instrument that you could use. The last point I'll make, because I don't want to go on too long, but Andrea raised the point of wanting to make sure that there was pinch with respect to the sanctions in order to enhance their credibility. And I think that's not a bad limiting principle in general, but I suspect if you were to go through the SDN list, you could probably find Al-Qaeda and Taliban and other perpetrators who have been designated over the grand sweep of time who don't have an enormous number of assets inside U.S. financial institutions. So I wouldn't want to hold to that too rigorously.
But I would say on the operational side, or even more on the, maybe it's an unintended consequence, maybe it's an intended consequence. Sort of this notion of what we're seeing now with GLOMAG is the notion of convergence, where your compliance programs are converging across, horizontally across your institution, be it a corporate or be it a bank itself, right? So your ABC program now needs to be communicating under the GLOMAG, at least from some of our readings, communicating with your AML program, who should be communicating with your sanctions program. Typically, those have all been siloed. Not all institutions are that way, but over the years, there have been movements away from siloing, but still there are silos. So I think an unintended consequence is this notion of convergence, which actually started with FinCEN's new CDD rule, where they said you have to share your information on your beneficial ownership with your sanctions program. So it's an interesting outcome, I think.
If I could pick up on a point all three of you made, for Jerry, in terms of measuring targets on either the UK or EU, whichever side you prefer to speak to, how much do you all focus on the value of impact, a link to the European financial system versus a messaging sanction? And do you run into the same challenges that we've seen between the administrations?
Thanks, Samantha. Well, I think, as Steve said, that the impact can be economic, but it can also be political and reputational. And so I think, in my experience of working in the EU, we've tended to start from the other end of the process and look at the activity that the person or the entity has engaged in to see whether they meet the criteria. And then there's a discussion about the political utility of actually imposing the sanctions. And as part of that, one question can be, how much is this really going to affect them? But I don't think that the economic nexus is a precondition. The reputational political issue is still, I think, quite powerful, and certainly within the EU there have been a number of legal challenges brought by those who've been listed under our geographic regimes for human rights violations, even though they haven't had any direct economic impact on those who've been designated. They have imposed a travel ban, but even where there hasn't been any great willingness to travel to the EU, people have still litigated because they don't like being identified and badged, for want of a better word, as human rights abusers. And again, to echo Steve's point, I think the more multilateralism there is in that approach, the more powerful it is, because it sends a message that a number of jurisdictions have looked at the activity and have all come to the same conclusion about it, and it counters the argument that it's an arbitrary use of the power. So I think it can be effective both where there's an economic nexus, but also on the reputational and political side.
You raised a good point on the multilateral side, which Andrea also alluded to. Could you speak maybe to additional coordination and looking forward, I guess, post-March or when Brexit may occur, with regard to the potential for additional cooperation, and the UK has its own individual authority on these types of sanctions activities?
Yeah, I mean, I think there's good coordination, transatlantic coordination in a number of areas over the years, and that's something that we definitely want to look to build on in the future, post-Brexit, where there will be the UK with its own sanctions policy, but looking to work very closely with the EU and with the US. And I think, again, in this area in particular, which reflects a lot of our common values, this is an area where really we can send very strong messages by coordinating our activity. So I think there's definitely an appetite on the UK side, and I think hopefully on the EU side, to coordinate as much as possible. It may be that sometimes we agree that the activity is reprehensible, but the way of addressing it might be different. But I think there is a lot of common ground often that sanctions are a useful tool in a number of these cases. I think the more we can share information, both between the UK, US and EU, the more helpful that is, but also to get information from NGOs and other sources in the area of human rights violations, because certainly the EU experience has been that there can be a number of legal challenges, and that will also be a possibility under the UK system. So if we are going to designate people, we have to be able to defend them both legally, but also in terms of political and public opinion. And it can be quite damaging to designate somebody and then lose that challenge in court, because that undermines the robustness of the sanctions and risks giving them a propaganda victory. So I think exchanging information and evidence is a key part of that.
And if I could pick up on one thing you alluded to, the NGO role. Steve, given the increased partnership and the role of NGOs in the Global Magnitsky sanctions and the ability for NGOs to nominate targets that the US government now considers, do you think this is a model that's working? Do you think it should be considered in other contexts?
So the NGO that I work for now is really more focused on conflict prevention than human rights advocacy, but I did talk to a number of my colleagues who have worked closely with Treasury. I think they feel very positive about the level of engagement that they have with Treasury and with state. And I think that's really a tremendous credit to you, Andrea. They really feel like there is an open door there. There was concern, just to go back to the scab that I'm going to continue to pick from the last administration, there was concern at the time that, if we went down this road and opened this door, that we would never satisfy the NGO community. But the truth is, the NGO community isn't all about self-satisfaction. What they're trying to do is present options. Obviously, I think, speaking for my own NGO, we think our analysis and recommendations are very strong, otherwise we wouldn't put them forward. But we don't necessarily expect that they're all going to be taken up, and we certainly don't expect that they're going to be taken up to satisfy us. The idea is that we're trying to help, countries, move towards policies that will be in their interests and the interests of the broader mandate of the organization. I think human rights organizations realize they're never going to achieve total, realization of their goals. So I think just the process has been useful. I think they feel like they are heard and needed. They're not yet giving you an A, but in the B range for sure, and that gives you something to work towards. But I think and listening to Andrea talk about this, my sense is that there's a general sense on both sides that it's a beneficial relationship. So yeah, I hope it is a model for other kinds of programs of this nature.
And I think maybe my last follow-up on this part for Clay specifically, when you look at the increasing role of NGOs in this particular sanctions authority and their ability to flag reputational risks and other concerns, human rights, kleptocracy, etc., how do you see businesses incorporating these broader risks into their risk model? Do you see them shifting a more proactive approach or waiting for a name to be slapped on a list?
So it actually splits down the middle. There are some people, some industry, folks in industry who are taking, and we had talked about this earlier, this idea of future-proofing, where you take a look at who your customers are, who you're doing business with. And certainly if you have someone on a list, you're going to not do business with them. But if there are folks who you think may be on a list, who, if you are mining some NGO reports, if you're taking a look at what's happening in the news, there are investigation units in some companies who are taking these reports and looking, do we have these people in our institution? What should we be doing with them? And it's all a risk-based approach, right? So the idea here, and everything is a risk-based approach. What does that really mean? When I was in the government, I would say, oh, of course, it's a risk-based approach. Now I'm in the private sector, I'm like, what does that actually mean? Because you actually have to follow that thread. And it's reputational risk, of course, but at the end of the day, I think folks are trying to figure out where is the reasonableness line, and we talked about that earlier.
I think if I could ask one more question, but switch gears entirely. When President Obama signed the Global Magnitsky legislation that was passed by Congress at the end of December 2016, he issued an accompanying signing statement. I'm guessing most people missed it. It was about 5 pages long. The very last paragraph is a few sentences long, where he highlighted at the time the perceived separation between the legislative and executive branch's ability to propose targets. And I'm just going to read the language so I don't completely mess it up. He noted that, quote, consistent with the constitutional separation of powers, which limit the Congress's ability to dictate how the executive branch executes the law, I will maintain my discretion to decline or to act on the names submitted by Congress for consideration under the Global Magnitsky Authority. So I think there's a lot to unpack there, but this particular issue has come to a head most recently last year following the murder of Washington Post journalist Jamal Khashoggi, and the significant number of discussions on the Hill with regard to asking the administration to take action. There's been discussions about whether or not the administration should target the Crown Prince, whether or not the actions that were already taken by OFAC and also by a number of European counterparts as well are sufficient. And I think that also leads us to the question of what role Congress should have in proposing individual names for sanctions when, a lot of folks would argue that Congress's role is to give the executive branch legislation and that the executive branch then implements that legislation. So I'd like to unpack that issue, which I think there's a lot there. And first, maybe I could start with you, Andrea.
So I think that the separation of powers issues that President Obama flagged in the signing statement hold true across administrations, but I am not best placed to solve that or sort that here. And I always look to esteemed legal counsel at Treasury and elsewhere for guidance on whether or not something is tripping over a separation of powers area. But I would say that we consider Congress as a partner in the application of financial sanctions, and we frequently receive nominations or suggestions for targets from members of Congress, and we take those on board. We evaluate them. Sometimes we act on them, albeit a little bit differently, but we always take them on board. When it comes to Jamal Khashoggi and the actions OFAC has taken, the U.S. government was among the first countries, the first country to identify 17 individuals and to apply sanctions to those individuals for their role in the murder of Jamal Khashoggi. I cannot speak, however, to the application of sanctions in any future context, and this is very consistent with how OFAC approaches sanctions matters. We act when we announce sanctions. That is when our intention as to whether or not to sanction is revealed. We simply do not discuss matters such as that in the public realm until they're announced.
Steve, do you want to pick up on the outside perspective?
So I guess on the signing statement, as those of us who've worked inside the executive branch know, a White House lawyer is always going to look for potential erosions in the president's authority and preserve them however that lawyer can. So I don't find it especially surprising that that's what the signing statement said. I don't think it's especially wise, though, to operate at the end of the discretionary envelope that signing statement created. There were ways to sort of respond to the October query that the SFRC sent down without necessarily conceding the ground as a matter of law. So somebody could have, and I think Rob Brzezinski has written about this, they could have written back and been responsive to the query, saying that they were acting consistent with the request, if not with the letter of the law. And that probably would have taken some of the wind out of Congress's sails. So I don't think it was, I think it may have been self-defeating, because it's going to continue to generate concern up on the Hill that the administration is stonewalling and not fully addressing the issues relating to the Khashoggi murder, which I think is probably an accurate assessment. So I don't think it was wise. I don't think it was necessary. And then I think it's sort of a missed opportunity for the administration as well, because as we all know, it can be hard for the executive branch to deliver tough human rights messages to its partners in the international space. Sometimes it needs a foil. NGOs can be that foil sometimes, but Congress is a particularly effective foil, particularly when you're dealing with partners, who are depending on longstanding, congressional authorizations and appropriations to do business with the United States. So what I would have liked to have seen, and what I think there's probably still an opportunity to see, is, the administration saying to its partners in Riyadh and elsewhere, look, we can't continue to stiff-arm Congress this way. We need you to work with us to make certain advances that satisfy their concerns. Give us something that we can tell them. I think that would be a more productive way to handle this conundrum than the way that they're handling it right now.
And if I could just pick up on that, Jerry, what does it mean for international cooperation if Congress is increasingly inserting itself in the specifics of sanctions implementation, or sanctions targeting? We saw it specifically in implementation with the recent consideration of the Rusal delisting and under CATSA, and under Global Magnitsky, with Congress proposing specific names to OFAC, and as Andrea mentioned, OFAC considering them. Does that impact international cooperation on the technical side?
Well, I think it's a separate arm of the process that needs to be engaged with, and from a UK perspective or from an EU perspective, that has to be done, and it's because of the separation of functions in the US and the possibility that Congress has certainly to legislate in some areas of Congress. I think that's something that on the EU side we've become more aware of, and it's just a fact of the process, and it's something that we have to engage with. But from what I've heard, Congress is very open to engagement and very interested to hear from third countries. So I think that's just something that we'll work on in the future.
Clay, did you see any impact on the business implementation side?
Well, certainly from a reputational risk standpoint, there's a lot of folks who are saying, if Congress is raising these folks, do we do business with these folks? And certainly with Elijah Cummings, Maxine Waters, and the committees, let's just say, a lot more active than they were. There's a lot of concern, who are we doing business with? And so there's a lot of culling of speeches, there's a lot of review of what's going on, of course in the news, but certainly where Congress is focused on. And then people take a look, are these customers, are these people we do business with? And if so, is there an area that we need to remediate? Are they okay to do business with? And that's some of the things we're seeing.
So with that, I'd like to open it up to the audience. We have folks running mics, and we have a lot of interested parties. Why don't we start over here, and I'll work my way around as time allows. If you could say your name and your affiliation, please.
I think there's another policy argument for restraint in use of the GLOMAG designation weapon, and I'd like to get some feedback on it. It relates to the fact that, as Andrea said, this is a preemptive weapon. You don't know the missile's coming until it hits and you're on the list. The point of the designation is to respond to what are typically regarded as criminal offenses where there's law enforcement jurisdiction. And Clay, in his capacity as a former prosecutor, and Steve as a policy wonk, I'd like to get your views on the appropriateness of putting someone out of business and turning someone into a financial pariah without a fair hearing. All of this is done without the alleged corrupt actor having a chance to defend themselves, which is a complete inversion of our whole constitutional process, where you are presumed to be innocent until proven guilty by a court of law. And particularly in a Khashoggi type situation, where the U.S. clearly has law enforcement jurisdiction, given the nationality of the victim, what is the defense of using a preemptive weapon of this kind in the absence of a overriding national security objective of the United States?
So I guess I don't see it as a preemptive weapon. I mean, when I started sort of engaging with the sanctions tool, it was in the context of atrocity prevention and mitigation, and it was frankly often in a situation where a lot of people had already been killed, and a lot more were sort of on the had that prospect of being killed. And so oftentimes you're dealing with situations where the bad act has already happened or is unfolding. The second is, I think, although I understand that there are contexts in which OFAC doesn't broadcast who it's going to be designating, certainly there are ways to develop diplomatic strategies where you make very clear to the country in question, and Dan is nodding because he did this, where you say, look, this is what our expectations are, and if certain things go wrong, if certain triggers are pulled, we are going to start designating people, and you can get very specific about it, and it can be extremely effective. And so when I alluded before to using this tool in the context of a diplomatic strategy, that's what I meant. And a particularly good example of that was the way in which Tom Perriello, who was at that point the special envoy for the Great Lakes, and others developed a strategy for pressing the Democratic Republic of Congo not to commit gross violations of human rights, or at least to mitigate some of them, and towards an agreement in 2016 that created the framework for the political transition that just happened. Now, it was hardly a perfect transition, and the whole process had plenty of warts on it, but people were really worried in 2016 that this enormous country might slide into an episode of mass killing. And I really do credit the diplomatic strategy and the leverage that the sanctions tool gave us for helping avoid that. I don't think that was frankly a situation where law enforcement would have been a particularly effective tool. I do think it was a very useful example for showing how sanctions can be integrated into effective diplomatic strategy to achieve very worthwhile goals.
And so on if I put my government hat back on, often, the Department of Justice has a couple of tools they can use, right? They can use, obviously, their criminal abilities, but also asset forfeiture, which is civil-based, right? And in that instance, and what you've seen over the years is an increased use of civil asset forfeiture, certainly in the 1MDB matter. And the idea is to work in hand with OFAC, hand in hand with Treasury overall, where folks are designated at the same time there's a criminal prosecution. So from the DOJ's, and I don't speak for the DOJ, but from the DOJ's perspective, the authorities that Treasury has is very helpful when you're focusing in on certain types of conduct that are a priority of the administration.
And if I could just add a layer on as well, just because it's something that I think the Treasury Department has thought about for a long time. Starting with the Kingpin Act, which allowed for the designations of drug traffickers, there was a great deal of tension in that is kind of a quintessential application of criminal authority. But the Kingpin Act filled a gap. It went against foreign persons and engaging in drug trafficking, cut them off, blocked their assets, and in so doing protected the U.S. financial system without having to wait for a potentially protracted criminal investigation with limited resources. That tool has then been replicated in many other sanctions programs with parallel criminal authorities, whether it's terrorism, transnational organized crime, and the like, and now it's come to corruption, human rights abuse. So in many ways, this is all of the piece. We've looked at this through many angles, but one of the overriding objectives of sanctions is to protect the U.S. financial system, and by placing someone on the list for having met our criteria, it does achieve that objective, but it's not a penalty, it's not a criminal penalty, it's not a forfeiture. The U.S. government's not taking title to the assets. No one can go to jail from OFAC. So there are some limitations to what we can do. Thanks, George.
All right, the gentleman in the white shirt, who has got the mic.
Aaron Zorman with Sigma Ratings, and I was wondering if I could ask the panel about what you see the trajectory of investigations and the private sector's due diligence and how that will operate in the next 5 years. Now, with the advancement of artificial intelligence, data analytics, do you see that there'll be more of a reliance on, linkages and algorithmic learning and programmatic discovery as opposed to the historical usage of a person behind a desk investigating these persons and finding out who they're connected to, shared board seats, and matters of that such? Is it going to be a machine finding this out, or are we still going to be relying on a person behind the desk?
I would just to speak to Treasury, the Treasury Department. We are very interested in exploiting the data in the most creative ways data under our control in the most creative ways we can. I wouldn't remove that from the human element of the investigator, but we are absolutely exploring better use and better tools to analyze, assess our data to come up with targets under this authority and others.
So this is something we are actively doing right now, working machine learning. We really call it machine intelligence, but in looking for both on transaction monitoring in the AML context, but also in ABC compliance, as well as your overall investigations context. But what I would note, and I agree 100% with Andrea on this, is that you cannot remove the human element. What we're seeing is that they work in tandem. That's where the best result happens. And you're only as good as the information you have. And the way machine learning works generally is you take historical cases and you plug them in, and and they run algorithms to create patterns and to look for what we call intelligent segmentation among data points, right? You cannot do that unless you have people who know what they're doing, real investigators, folks who are looking at the information. But I will say we're actively working with clients right now in this, and you are finding better things. I mean, you are finding more productive alerts in the transaction monitoring context, but you're also finding linkages that you never thought you would find on the ABC side.
I've got nothing.
Sure, in the back.
My name's Timothy Towell. I'm a retired Foreign Service officer. I'm sorry I came in late. I'm also sorry I seem to be older than a number of my colleagues here. I'm a 19th century person, went in the Foreign Service in the Kennedy administration and was there 30 years as a political officer. I'm sure sanctions worked back then, but I don't even remember any of them. But I remember a lot of people that went to heaven or other places, including Noriega, dictator Panama, and a lot of other bad guys. My question is, are sanctions working in a really horrendous place? I hope, how many people saw TV yesterday, humanitarian aid trying to go into Venezuela and all of it being burned down, people shot, people beat up by not only nasty Venezuelans, but Cubans and Russians, by the way, 400 of them. Is it working? Are sanctions in the 21st century working in a nasty, nasty place like Venezuela? We just added 3 more governors, didn't we? But how about the zillions of people? Marco Rubio loves Florida. They vote for him. They're Cubans there. But there are 1 million Venezuelans. Half of them are nasty. And they take their money and their girlfriends and their wives out and put them in U.S. banks. I don't know if it's money laundering or not.
So
Can't we go after them too in Miami? Marco knows where they are, and I do too.
So if we can focus on the impact of the sanctions, we can start on the Venezuela side. Andrea?
Sure. So, the sanctions, Treasury Department, the U.S. government has been incredibly active in trying to take all steps to deprive the Maduro regime of the assets it needs to sustain itself. In light of a legitimate government on the cusp of taking over. and a few weeks ago imposed sanctions on the state-owned oil company PDVSA, as to which there was a huge corruption scheme behind it. And this was, even though it wasn't GLOMAG in particular, it's an example of Treasury, the U.S. government taking action under authorities with corruption or human rights related abuses. As you can see, we are incredibly active. We took action yesterday to impose sanctions on 4 governors whose states have taken action to deprive the Venezuelan people of the much needed humanitarian aid. Sanctions are one tool, but right now we are using them as quickly and as smartly as we can to try to make sure that the Maduro regime exits the scene.
Jerry, I don't know if you want to comment on the European side.
Well, I mean, from an EU side, the sanctions are pretty limited, but they're targeted, and the principle that we've always adhered to, certainly in the last 20 years, is to focus on those who are responsible for the activity, but to work very hard to avoid unintended impacts on the civilian population. And I think that goes back to the experience during the first Iraq War and after the first Iraq War. So I think whenever we talk about sanctions, we've got to always bear in mind that we need to ensure as far as possible that we avoid unintended consequences impacting on the innocent civilian population. And so it can look as if a few names on a list is pretty minimal when you've got a very serious situation in a country like Venezuela, but equally it's about targeting. It's also about an escalatory approach. So we start at a reasonably modest level, but we have room to go up if there isn't a response by a change of behavior.
And I'd associate myself with that approach and those remarks. I don't know whether the administration's somewhat high-risk approach to Venezuela is going to work, or whether the sanctions tool will look in hindsight like it's a bit heavy-handedly used there. Generally, targeted sanctions are a preferred approach, I think, at least from my organization's perspective. The only other thing I would note is the question was framed, can sanctions help in genuinely nasty places? I guess I would just reframe that as, can sanctions help in very complex crises? And that question it depends on the crisis, it depends on the actors, it depends on the strength of the diplomats involved. I think they can help. We've seen that they can, but to, I think, come up with a sort of sweeping generalization about it is very difficult.
Well, I think there's a lot more to unpack there. I'm getting waved at that we are unfortunately out of time. So I apologize for those of you whose questions I didn't have a chance to get to. But if you could all join me in thanking our panelists for their remarks and their insights. And thank you all for joining us. We hope you got a lot out of the program.